Written contracts of employment can be very important tools in an employment relationship. Contracts set out the essential terms and conditions of the employment. Whether it be start and end dates, compensation and incentives, vacations, termination entitlements, or anything else you can think of, a written contract is an opportunity to simply and clearly set out the terms and conditions of the relationship, hopefully helping to avoid confusion and disputes. In my view, the most important part of any written employment contract is the termination clause. When properly drafted, it tells both the employer and employee what their respective rights and obligations are in the event that either party wishes to terminate the relationship. A well-drafted termination clause can help reduce disputes and avoid expensive wrongful dismissal litigation. When an employee is asked to sign a written employment agreement, they must receive something of value in exchange. We call it consideration for entering into the contract. Without it, the written agreement may not be binding. Let me illustrate for you. When a new employee is asked to sign a contract as a condition of accepting the new job itself is the consideration for the contract. Where an existing employee is asked to sign a contract, they must receive something new of value as consideration. Promotions, raises, or other such benefits are examples of valid consideration. There are numerous circumstances where termination clauses will not be enforced by our courts. The most common reasons would include things like lack of consideration, poor drafting or ambiguous language, or a termination clause that provides for something less than the minimums required by the Employment Standards Act. These are the types of mistakes that employers can make that cause judges to say that termination clauses will not be valid or enforceable against an employee. Where a contract is silent on the issue of termination, or if a termination clause is not enforceable for any reason, then the common law applies. Under the common law, the employee will be entitled to reasonable notice of termination or pay instead, unless, of course, there's just cause. If you'd like to learn more about entitlements on termination, see our related video on the topic of terminations without cause. Written contracts of employment can be very powerful tools, if they're done right. Employers who are hiring or who otherwise wish to introduce contracts into their working relationships should consult with knowledgeable counsel so that they can rely on these agreements in the future. Similarly, employees being asked to sign contracts should definitely get appropriate advice so that they fully understand their rights both during the relationship and at the time that the relationship might be terminated. I'm Peter Straszynski.